Receiving stolen property is a crime. Does a conviction require that the defendant physically handled the stolen items? In State v. Jennings, the defendant merely stood next to them. Late one December evening, Melody Kay pulled into her boyfriend's place of work to pick him up. Kay left the car unlocked and went inside to greet her boyfriend. She left several items in the car, including a case of Miller Gold beer and her purse, which contained a CitiBank credit card and Bank One debit card. 5 minutes passed. Kay returned to the car. Her purse and the beer were gone. She immediately called the police to report the incident. 3 men, including James Jennings, were seen running from the parking lot where Kay's car was parked. Police officers pursued them into the nearby woods. The officers saw Jennings with 2 other men laughing and drinking Miller Gold beer, the same beer Kay had in her car. The officers told the men not to move. Jennings stayed, but the other 2 men fled. The officers pursued the 2 fleeing men. After apprehending them, the officers returned to confront Jennings. He had moved roughly 15 feet from where he had been when the officers first arrived on the scene. At Jennings's feet, officers found Kay's credit card and bank card. State law criminalized the receipt of stolen property. Although the offense was generally classified as a misdemeanor, state law treated receipt of stolen property as a felony if the defendant received a credit card. The state charged Jennings with 2 counts of receiving stolen property. 1 count was for the bank card and the other for the credit card. Jennings argued that he wasn't in possession of the stolen cards and that the felony enhancement wasn't applicable to the count for the bank card. The court rejected his arguments. Jennings was convicted of both counts, and he appealed to the Ohio Court of Appeals.